Okay, good afternoon. I would like to call this meeting of the Human Relations Commission to order. We have in attendance myself, Commissioners Delabasic, Jackson, Bannister, and Stewart. From my fellow commissioners, can I get a motion to adopt our agenda for today?
I'll put a motion to adopt.
Can I get a, all in favor?
Aye.
Any opposed? Okay. Well, welcome. Thank you all for coming out today. My name is Megan Gertie Walters. I have the honor of serving as the chair of the City of Sioux Falls Human Relations Commission, otherwise known as HRC. HRC has organized this event today, so I wanted to begin by giving you just a quick overview of what HRC is. We are a volunteer citizen board housed within the City of Sioux Falls Human Relations Office. HRC works to promote civil rights and equal opportunity for Sioux Falls residents in the areas of employment, housing, public services, public accommodations, financial institutions, insurance companies, labor organizations, and educational institutions within Sioux Falls. Our Human Relations Office is staffed by Amber Mulder, Senior Assistant City Attorney, and Lindsay Meyer, who's in the audience, our Human Relations Specialist. Our commission is currently made up of 7 volunteer members, many of whom are in attendance today. Myself, Commissioner Elmar Delabasic, Tawan Jackson, Sheku Bannister, and Vicki Stewart. So thank you for attending today with us. April is Fair Housing Month, which commemorates the passage of the federal law that prohibits discrimination in housing and reaffirms our commitment to promoting equal opportunity in housing. So while this event isn't solely focused on fair housing, it does provide that inspiration for the event. As we know, in recent months, both here in Sioux Falls and nationally, there's been a lot of attention on landlord-tenant issues, rights, such as issues with poor living conditions at rental properties, property maintenance concerns and questions, questions about utility billing, and lack of affordable housing, just to name a few of those concerns. And with those issues come questions about where tenants can turn to for assistance. The City of Sioux Falls fields a lot of those questions and with those tenants and really tries to steer them to the appropriate entities for assistance. We completely understand much of the confusion and frustration that individuals and families may face and experience when they are transferred from one division within the city to another to the next, only be told that it's ultimately a landlord-tenant issue that the city doesn't really have authority over. So with this panel, we hope to answer some of the more commonly fielded questions that we receive, clarify what the city can get involved with, and where calls on certain issues should go within the city, and as well as hopefully let people know where they can turn to if the city isn't able to assist with that particular matter. So with that, I'd like to introduce our panel for this afternoon. We have Logan Penfield, who is the Housing Development Manager for the City of Sioux Falls. He works in our housing division that connects people in Sioux Falls with resources to ensure safe and sustainable living conditions. Logan's division works to ensure access to fair and affordable housing. Programs that he oversees or works with include Public Safety Down Payment Assistance Program, the Mobile Home Repair Program, Neighborhood Revitalization Program, Rental Rehabilitation Program, and the Single Family Rehabilitation Program. So welcome, Logan. Next, we have Justin Christensen, Property Maintenance Inspection Manager for the city. Property maintenance also falls under housing, and it addresses issues with buildings or units such as plumbing, mechanical, electrical, and or fire protection systems. So think about broken windows, doors, leaky pipes, exposed wires, broken heating systems, and also, that nuisance vegetation, long grasses, weeds, snow removal issues, piles of garbage or yard waste, non-working vehicles, animal waste, all that stuff. So welcome, Justin. Next, we have Amber Mulder, who is a Senior Assistant City Attorney within the Human Relations Office. As referenced earlier, Human Relations handles complaints of housing discrimination under Chapter 98 of City Ordinance and promotes equal access through education, outreach, and technical assistance specifically related to fair housing laws. Fair housing laws prohibit discrimination in housing based on race, color, national origin, religion, familial status, sex, and disability. Welcome, Amber. And then finally, last but not least, we have Jill Swanson, who is a staff attorney for East River Legal Services. East River Legal Services is a nonprofit law firm committed to providing civil legal aid, to people in eastern South Dakota. Many tenants do not know their housing rights when dealing with landlords or court issues related to housing, and that's where East River Legal can step in. They provide housing assistance for tenants in the areas of eviction, repairs, non-renewal of lease, and termination of lease. So Commissioner Delbasic and I will moderate this panel discussion. We will begin, the two of us, by asking the panel some of the more commonly asked questions that we receive. Then we will open it up to the audience, to the public, for some questions as well. We ask you to keep in mind the panelists that we have here with us today and what kinds of questions that they may be able to speak upon. As a note, we will have time following the panel discussion devoted to public comment, where any members of the public will have time to take and can take advantage of that time to state any other issues that they may want to bring forth at that time. So I will turn it over to Commissioner Delbasic to start us off with our questions.
So the first question that we have that's pretty common is, as housing costs continue to rise in many communities, what steps is the city taking to ensure affordable housing remains accessible, and what programs are in place to support low to moderate income families?
Sure, thank you for the question. So we have a handful of different programs that we administer through the city to address the need for safe, sanitary, affordable housing for low to moderate income families and individuals. First off is just our largest program is single family rehab. Our single family rehab program leverages community development block grant funds to provide zero interest deferred loans for income restricted families to stay in their homes. So we have a lot of elderly folks that are income restricted, that have been in a house for 40 years. They might have an HVAC system that's failing, or a roof, or windows, anything that you'll start seeing the house go backwards, but become less safe, less sanitary. We'll provide a zero interest loan for those. They'll be able to get that repair or replacement of that HVAC system done, and it helps them stay in their home, maintain the equity. We never take repayment on that loan until they either sell the house or move out of the house. So that's probably our largest program, and that's income restricted at 80% of area median income and below. We spend about $800,000 to $1 million on that program annually. We have a rental rehab program which leverages 0 to 3% interest depending on rent over 8 years to help rehab older apartment buildings that are targeted for lower rent. So you get a lot of the older 4, 8, 12 plexes that take advantage of that. We work with multiple different nonprofit partners across the city and for-profit partners to try to create first-time homebuyer first-time homebuyer homes, new first-time homebuyer homes across the city of Sioux Falls. Affordable Housing Solutions leverages our home investment block grant funds. We use some community development block grant funds to work with Habitat for Humanity, and then some one-time federal funds and some city funds. We work with the Southeast Development Foundation to recycle houses and to bring governor's houses into the city of Sioux Falls for again, 80% of area median income restricted homes. We're able to do really creative things with our funding sources because we have state, we have federal, we have city, we have one-time funds that have different rules. And so it's not just one large program, here's what we're going to do. It's a bunch of smaller programs that add up to have a pretty substantial impact in the city of Sioux Falls. One thing that's about halfway in to its overall life is a TIF district out on the northeast side of Sioux Falls, which produces 66 units, all sold at or below the first-time homebuyer price limit, which is something, the first-time homebuyer price limit is set by the State Housing Development Authority, and that's limited to 80, and then it's not limited to 80% of area median income, but the price is limited to folks that qualify for that program. So it was a more creative way to do a larger development. There's 66 houses, there's 3 different footprints. In that development, it starts at $230,000, goes all the way up to I think $310,000 there. And it's 2-bedroom, 1 bath, 3-bedroom, 2 bath, and then 4-bedroom, 2 bath. And it's a different footprint. We reduced some setbacks. Each of the homes is a 1-stall garage with a 2-stall driveway, something non-traditional that is being tried for the first time within a development like that. And it's all available to first-time home buyers and fits that low to moderate income household goal. So it's a handful of different things that you try to do. You try to work with your partners, and it ebbs and flows, you know, with the availability of federal funds, state funds, city funds, and then the availability of your partners to work with you. So it's a lot of little things that add up to some pretty substantial impacts.
So where can someone that's interested in these programs find out where they are and if they qualify?
So if you're interested in any of the city administered programs, on our website, you can apply online, siouxfalls.gov/housing. We have online application software there. If you're looking to purchase a house, which we don't sell, we work with partners to purchase, they list those on the MLS, and they also list them on their own websites. So Habitat's a little different because you have to get into Habitat's program, and there's some sweat equity that's required in there. And they do a little deeper income targeting because of that, because they're the way that their business or operation functions. But Affordable Housing Solutions website lists their homes for sale directly on there. Southeast Development Foundation, the same. And then Nelson Construction, Kelly Nielsen, has it on his website as well. It's also listed by an agent, so it'll be on the multiple listing service where you can search those.
Great, thank you.
Can you explain some of the most common legal challenges tenants face when it comes to housing, and what resources or strategies are available to help them protect their rights?
I think this is probably a good question for me to answer. So at East River Legal Services, I help with a variety of civil legal issues. And these days, about half of what I'm doing is helping tenants to enforce their rights in many scopes of the rental relationship. And oftentimes that is including repair work and evictions. And those would be the 2 issues where I see tenants having the most legal problems. For repair issues, the statutes are very specific on the process you need to follow in order to withhold rent, and then what options you have if the repairs are still not made after withholding rent. And a common issue we see is just that people don't know what that process is before attempting to withhold rent and engage in that process. So it's important to find the information you need to successfully withhold rent and to follow those procedures before engaging in that process. Something that is also a struggle with repair issues is that the statutes are not extremely clear on what types of repairs allow you to withhold rent. They use a variety of terms, like ordinary wear and tear is a term you might see, or fit for human habitation, or safe and good working order. There's not specific definitions of those. So my best advice to tenants would be to document everything that you're seeing. And if this compiles into a large enough issue, then consider the rent withholding option. Take pictures, take videos. Do you have friends that have been to your apartment and see these issues? Talk to them about it, and if they can help, testify at a hearing if needed about the issues that they've seen. The second issue that I see facing tenants the most would be the eviction process, and that can kind of result from some of these repair problems. Say that someone is improperly withholding rent for that repair work. If they're not doing it properly, that might result in an eviction action being filed against them because they have not paid their rent and they have not withheld that rent properly. With evictions, it can be difficult to get access to the courts and get things filed properly and on time. That process moves extremely quickly, and I do have some handouts with me if anybody wants to have a quick 1-page handout of the legal eviction process. But In terms of resources, if you're having a problem with your landlord, you're welcome to apply for services with East River Legal Services. We do have income restrictions, but if you qualify for services, everybody gets at least some advice and directions on what is this legal issue and what options are available to you moving forward. If it's more serious or if we feel we have capacity, we're happy to offer direct legal representation to those cases we feel are appropriate.
Thank you. The next question, what roles does the city play in ensuring that landlords comply with housing quality standards? And how are these standards enforced to ensure safe, habitable living conditions?
Okay. Well, first of all, what our role is we have to define a standard. What is the standard? And we do that through the adoption of different codes and ordinances. And as it pertains to property maintenance, we adopt the 2021 version of the International Property Maintenance Code, and we follow the Chapter 160 Code of Ordinances. The Property Maintenance Code kind of outlines and deals with the building structure itself, interior, plumbing systems, electrical systems, flooring, appliances, and exterior building structure, missing siding, broken windows, missing handrails, things of that nature. And the Chapter 160 Code of Ordinances is where we kind of fall in line with maybe operating an illegal business, illegal parking outside, number of people living in the home, things of those natures. So we have adopted those codes and ordinances, and they kind of become final rule. It kind of sets the standard for property owners, telling them how they need to maintain their properties and in what state. And then we have to have a process to enforce that. So by having, first defining what you can do, what is rule, that becomes required, not recommended, and then our process for following through on that. In the city, we're primarily complaint-based, so we'll receive a complaint from someone in the public. We will enter a code case in our system. We will go out and do a physical inspection on site to identify any violations that exist. We will write up a notice of violation for the property owner, notifying them that they are required to maintain their properties up to this standard, give them a time frame to complete that. We will come back with a follow-up inspection at a date that we put on our notice. Could be, for something like heat, could be 2 days, could be 2 weeks. A lot of times with property maintenance, it's 30 days. So we'll follow up after that time frame is completed. If it's been completed, that's great. We want compliance, right? And if it's not, we have a citation process that we can follow for encouragement. We 3 citation process, the first being 100, second being 200, third being 300. If that still doesn't generate compliance, then we can refer cases to our attorney's office and seek further enforcement through that.
It's a bit of a follow-up to that. If a tenant has contacted their landlord or property manager for repairs, does that landlord or property manager have a certain amount of time that they need to respond by? At what time is the tenant able to, for example, call for inspections or things of that nature?
So what we ask for is a reasonable amount of time, and that's in some ways a personal preference, probably dealing with the importance of what you're looking at. If it's heat, you're not going to wait 2 weeks to call. I would reach out. If you don't hear back from your landlord within 24 hours, I would be reaching out to the city right away so we can try and get in touch with those folks. In regards to, missing 2 burners on the stove that don't work, and you notify your landlord, and maybe he says he orders parts, you could check in maybe a few weeks later, and if you're not getting a response at that time, then maybe reach out and we can see what's going on then. But based on the importance of it, we're going to allow, for the most part, 30 days for repairs that are non-life threatening.
If a tenant needs accessibility modifications to their apartment, do they have to pay for it, or does that the landlord's?
And I can take that one. Most often, it's the resident that bears the cost of that modification, unless it's a multifamily residence that's built for first occupancy on or after March 13 of 1991 that's not accessible for persons with disabilities. The resident making the modifications also bears the cost of restoration. However, if the property is a recipient of federal funding, then the owner of the property is responsible for that, for the cost of the modification in order to comply with Section 504.
Thank you. We will now open it up to the public to ask their questions that they may have at this time. Again, we do ask that you consider what kinds of questions may be appropriate for this panel to speak on, and recall that there will be a time for public comment at the end. So you can come forth and ask your question.
Hello. Hello, guys. I'm Cassidy. I'm on the Human Relations Commission, and I had to come a couple minutes late, so apologize if this has been covered, but I know the city has some neat programs for like rehabbing. I think there's a trailer, maybe specific program. Can you guys just speak a little bit on how those work?
Yes, we have a program that it's very similar to our single-family rehab, where, but the cap is $5,000. It offers any kind of approved repairs, so anything that's structural, your HVAC system, that, you know, windows, doors, siding, roof, up to $5,000, and that's a forgivable loan. So as long as you live in that trailer for a full calendar year after completing that, that loan is forgiven.
All right, well, if you have questions, feel free to come up and ask them. Otherwise, we will continue to ask some of the other questions that, common questions that we have seen recently. I'm asking, what can a tenant do and where can they go if they are being discriminated against by another tenant, for example, has reported it to the landlord and the landlord has failed to respond to that issue?
So I can answer that one. Landlords typically are not directly liable for tenant-on-tenant discrimination, but in that situation, we would probably recommend that the tenant either call Human Relations, HUD, or even East River to discuss if they have any options available to them. It might be a situation even where a landlord would let somebody out of a lease early.
And to follow up with that, if that discrimination would rise to the level of, say, stalking or harassment that would be happening within the apartment complex, that tenant could have the opportunity to apply for a stalking protection order. That would be different than a domestic violence protection order, but the process is similar, and those forms would be available online or through the court system. And that's another remedy that could at least offer them protection while in the unit from that individual if that protection order were to be granted.
Is there a list or is there of apartment complexes in Sioux Falls that have wheelchair accessible apartments, and is there a waiting list for that, or does anyone know of any sort of?
I'm not aware of any such list.
What about if there is some kind of an infestation problem in a rental property? So for example, mold, bed bugs, or other kinds of pests. Who's responsible to fix that? Is there anything that tenants can do in these situations?
So with infestation, it's the responsibility of both the landlord and the tenant in multifamily housing. Once a tenant moves in, they are accepting that unit clean, sanitary, infestation-free, and at that point, it's the responsibility of the tenant to treat the inside of their units. It's landlord responsibility to treat all hallways, common areas, things leading in up to the door of the units. If there is a severe infestation, and the tenants don't take action to do something themselves, we will leverage some weight against the property owner to take action, as, you know, it's going to spread to other units and things like that. So there's shared responsibility in that. In some cases, we do have to step in and require property owners to do a little more.
If a tenant has, let's say, a necessity such as water shut off, is there, and if the landlord is paying for it, anything such as electricity, water, gas, whatever it may be, and that gets shut off, does the city have any programs that helps tenants pay for that or helps get that turned back on?
The city doesn't have any utility assistance programs. The county is where we would direct you in that scenario. My understanding is if the utilities are being paid for or are included in rent, and rent is paid, and utilities are shut off, that's not something that can be assisted with. If the tenant has line items on their rent where they owe X for water and electricity, and then just their unit is shut off or threatened to be shut off because they owe utilities on that, then there could be assistance available. But if it's included in rent and not line itemed out, and then it's paid, and the building is being threatened to be shut off in mass, that would be challenging because there's not really a recourse there from a repayment side of things.
And for payment or for utility issues like that, it's, I can't speak specifically to if the utilities are shut off because payments have not been made by the landlord, but if a landlord were to purposefully diminish those services for a tenant by shutting them off intentionally, and that goes for electricity, gas, water, heating, any other essential service, that can be considered an illegal lockout and as effective as an eviction, and a tenant could either sue to have those turned back on, take that as a termination of the lease, and otherwise there could be monetary damages available to them if that were to happen.
From the aspect of code enforcement, there are required utilities for a unit to be occupied. Water, electricity, gas for heat. So there are some essentials that are required, and from our perspective, if you are without, we would deem that property to be uninhabitable, and likely issue a notice to vacate.
While we're on the topic of utilities, we've been hearing more lately about something called ratio utility billing, or RUBS. Can anyone explain how it works and if there are any rights that tenants have when it comes to this?
I can discuss a little bit of what I know. The difficult thing about ratio utility billing is there might not be a lot of information available to the tenant of exactly how this algorithm might be operating and how those fees are being allocated to the tenants. What I've seen recently is that it's being used where a tenant is being billed based off of how many people are in their unit and the square footage for that apartment. There's currently nothing in South Dakota that would restrict that type of billing system from being used, but there are other states and municipalities that do restrict that, stating that single meters, or there's required to be meters for each apartment in order to engage in that type of billing system. It can be very difficult for a tenant to get any information from the utility company or provider about how much maybe electricity is actually being used in that building and if that lines up with how much they're being charged. So there are, frankly, not a lot of resources for tenants in South Dakota for ratio utility billing, but that's why it would be very important before moving in and before signing a lease to read the lease thoroughly and understand how you're being billed in those different items, and if it's best for you to try and seek a different apartment opportunity based off of that offered lease.
Can landlords deny housing to someone with a service animal?
I can take that one. No, it's important to understand that service animals or emotional support animals or assistance animals are not pets. So even if a landlord has a no pets policy, that doesn't apply to service animals and assistance animals. So if an applicant or tenant can provide documentation indicating a disability-related need for such an animal, the property will typically need to allow it, but there might be situations where they can exclude it, but that would have to be on a case-by-case basis.
So a big thing now nationally that I've seen is these ESA-approved animals that people go online and they register their animal and they have someone call. Would that be allowed to be used as an ESA with that type of documentation?
A landlord would not be required to accept that as documentation. There's no national registry. And a landlord can require that the documentation be provided by a provider with personal knowledge of that individual and their need for that animal.
Can you speak just a little bit further about the differences between a support animal versus a service animal?
So under the Fair Housing Act, an assistance animal is an animal that does work, performs tasks, assists and or provides therapeutic emotional support for individuals with disabilities. These are assistance animals. They're often referred to as emotional support animals or ESAs or even companion animals. And so under the ADA, we have the service animals, which are limited to dogs and miniature horses, and they are individually trained to do work or perform tasks for the benefit of the individual with the disability. And because of their protection under the ADA, they're typically allowed in most public places.
Bounce around a little bit. When can a landlord evict a tenant, and what does that eviction process require? Can we kind of walk through that process and help us to understand what is all involved in that?
Yes, I can take that question. So this is a lot of what my office deals with for tenant applications. So in South Dakota, a tenant can be evicted for essentially any violation of the lease contract. So it's important to read your lease, understand your lease, and make a plan for how you're going to follow that lease. If your lease has specific things that you need to do, like removing snow from the sidewalk in front of your house, then you need to make sure you have a plan to remove that snow for the winter time and ensure that you're not getting lease infractions. And this is, my commentary on this is specifically about private landlords and not for properties that are covered by housing authorities. That would be slightly different, and there are some federal rules that can apply for that. So if you violate your lease agreement, and the most common lease violations would be non-payment of rent, late payment of rent, or habitual lease infractions. And that can include anything from, noise complaints, maybe pests, garbage, unauthorized occupants. There's a variety of things that could come up. I've really seen a wide variety of things come up as lease infractions. In 2024, the legislature did enact a new law that removed the notice to quit requirement. Previously, there was what was called a notice to quit, and that was a letter sent from the landlord to the tenant explaining, you have committed this lease violation, and for that reason, I'm going to start the legal eviction process. Some landlords are choosing to still use this letter, and I encourage people to still use this letter. I think it's a very useful opportunity to engage in some negotiation and problem solving prior to involving the court system. But it is at this point up to the landlord if they want to provide that notice to quit. Again, there are federal housing programs where a prior notice may be required, and if it is listed in the lease that there is a requirement for that, whether it's the law or not, your lease is binding on that point. After that notice to quit period, that is when the tenant would get served with the summons and complaint. And the summons and complaint is the formal legal paperwork stating, I'm suing you for an eviction. In South Dakota, it's called forcible entry and detainer is what is most likely going to be listed on the top of that document. And that is served either by a sheriff or a private process server. Once that service process starts, so the sheriff, I'm just going to say sheriff for the example, would serve that paperwork once. If they don't find the tenant when they attempted to serve them, they have to wait 1 week and then 1 week later come back and attempt to serve them a second time. If the tenant is still not found on that second instance, that's when the paperwork can be taped to the door and then mailed to the tenant, and that's considered effective service. This is a really important distinction from other types of civil legal action in South Dakota. Personal service is required to be attempted but not completed. The eviction action can still start even if it was not hand delivered to the tenant, as long as those rules are followed. After that tenant receives the paperwork, so either after they're served or after it's mailed to them, they have 5 days to file a formal answer stating they dispute the eviction. And that 5 days does not include Saturdays, Sundays, or legal holidays by state statute. If they do not file an answer, a default eviction will be entered against them, and that is typically done without a hearing. I see lots and lots of tenants come to my office who have been evicted and they didn't know the eviction was starting until the sheriff shows up at their door to remove them at the end of that period of time. It's also very common for landlords and their attorneys to not file that summons and complaint with the courthouse until after the deadline for the answer has passed. This is a process called pocket service. It's somewhat unique to South Dakota. There's only a couple states that allow this type of process because of the high concerns for due process and whether or not someone is actually aware of the lawsuit that is pending against them. So very, very often I see tenants who try to go to the courthouse to file an answer and are turned away by the clerk of courts because there's not actually an open file in the system. And just because there's not an open file in the system doesn't mean that eviction action might not actually be pending. It's likely that it was mailed to them and maybe they have not checked their mailbox yet. So the process moves extremely quickly, and it is very important for tenants to see the documents, check your mail regularly if you're having problems with your landlord. If you get those documents, you need to respond to them immediately and send a piece of paper to the landlord's attorney saying, I'm disputing this eviction and the reasons for your dispute. Blank copies of that answer form can be found either with the courthouse or online on the UJS website. UJS is the Unified Judicial System, and they did just revamp their website this week. It looks great. There's a lot of forums. It's very easy to navigate, so I encourage people to check that out too. So if it's a default eviction, then it's likely that that judgment is going to say the tenant needs to leave effective immediately whenever it's signed by the judge. If the tenant does file an answer, a hearing can be scheduled as soon as 2 days after that answer is received. If the tenant doesn't appear at that hearing, it will be a default again. At that hearing, they need to present all evidence they have for why, no, that lease infraction wasn't me, yes, I did pay my rent, or whatever other kind of defenses they might have. In my experience, it's extremely difficult to fight an eviction action. If you haven't paid your rent, unfortunately, it's almost certain that you're going to be evicted. The judges in Minnehaha County, specifically in Lincoln County, I see on average of about a week of time to move out of your unit, and if you are not out, that's when the sheriff's officer is allowed to come and perform that lockout procedure. After you move out, if you have property left at the apartment, it's a very common issue. If it's assumed to be $500 or more worth of property, which more often than not, that's how much property people are leaving. $500 accumulates quite quickly with personal property. The landlord has to store that property for 30 days and allow them the opportunity to collect it. If it's considered less than $500 worth of property, they have to store it for 10 days. After the period for picking up the property has passed, then the landlord is allowed to dispose of it as they see fit. For mobile homes specifically, your mobile home, if you own that mobile home, is considered property that has to be moved within 30 days of that judgment. And if it is not moved from the mobile home park, it can also be assumed by the landlord and disposed of after 30 days.
Can landlords refuse to rent to someone with a disability?
No, they can't. It's prohibited under the Fair Housing Act.
And can landlords ask individuals with disabilities what their disabilities are?
Typically, no.
We already covered earlier that if there is a tenant struggling with another tenant in terms of discrimination, but what about other tenant-to-tenant issues? So for example, a neighbor blaring music late at night or causing other disruptions, and the property manager or the landlord doesn't seem to be addressing the issue. Or is there anything that tenants can do in these cases?
In regards to noise complaints, we don't have, the property maintenance code doesn't govern any of that, but the police department. It's important to remember not to call 911, but likely call the non-emergency number and notify the police department, and they can come out and deal with some noise complaints.
Okay, before we finish up with the questions and move on to public comment, I would like to give each of our panelists just one last chance just to speak to any other really common issues that they see in their departments, things that they really would like the public to better understand about what services that they provide or what they can do for everyone in our community.
I can start off. So for tenants, my best advice outside of some of the things I've already discussed is just to, as best as possible, keep in communication with your landlord and document the issues that you're seeing. Make sure that you can get everything in writing anytime you're discussing anything with your landlord. I know there are landlords who might refuse to answer emails or texts or letters and engage with that written communication and maybe only answer someone when they call them on the phone. If that's the case, if your landlord only answers the phone, have that phone conversation with them and then type up an email saying, I just want to document what we talked about over the phone today. These are the issues that I've discussed, and this is what you've said back to me about our plan moving forward. Anything you can do to create that paper trail of evidence to help enforce your rights later on if it does come to a court hearing is going to be very important. Sometimes this documentation is most important right at the beginning of your lease. Read your lease, understand your lease, take pictures of your unit when you move in. If there's something in your unit that is not fixed, is not safe when you move in, you need to contact your landlord immediately and say, this is not what the unit looked like when I toured it, or this needs to be fixed right away. Don't wait for something to become a problem, be as proactive as possible. I know that's easier said than done, and not everybody is gonna respond to that appropriately, but setting yourself up for a good defense is really your best bet as a tenant.
And you already covered what our office does in human relations. I would just add that if anybody has a complaint of housing discrimination, they can file that with human relations, with HUD, or even privately in court. But individuals can't dual file, so that means if they filed with our office, they wouldn't also be able to file with HUD.
And again, I just want to reiterate that our job is to uphold the community standard. There are requirements that landlords have to maintain their properties, and we want to know about those. So don't be afraid to call us. If you're not sure that it's something that we can handle, call and ask us anyhow. We're here to hold landlords accountable, all property owners accountable, for that matter, to provide a clean, safe place to live. So please call. The best thing we can do, that you can do if you're a tenant, is to call in. Sometimes if you email or send a complaint online, there's not enough information to get in touch with you to schedule an inspection. So the 605-978-6900, just call us and ask, and we'll provide any help that we can.
I guess the only thing I would add is just to reiterate the fact that we do have resources available to help people with home repairs, just necessary repairs to stay in your house. We do have some assistance for that we partner with ILC on for rental modifications. So there are different programs available. If you want to learn more about those, please go to siouxfalls.gov/housing.
I just want to say thank you very, very much to each of our panelists for sharing your time, your information, your resources, and your expertise with us today. We hope to continue to partner moving forward in similar events in the future. We will now open it up for public comment for anyone who would wish to come forward and make a statement. Just as a reminder, this is a time for comment only. We will not be providing any responses or answer any questions during this time. Each individual can have up to 3 minutes for their comment and is also asked to state their name when they approach. Okay. Hearing no public comment, we will move towards adjournment. And so for my fellow commission members, if we can get a motion to adjourn. Okay. Commissioner Smith made a motion. Can I get a second?
I'll second that.
Second, Commissioner Del Basic. All in favor?
Aye.
Any opposed? Okay. Well, thank you so much, everyone, for attending today. We sincerely appreciate you taking the time to be with us. Thank you.